Good morning, Whiplash Group members and followers. Hey, I've got a special guest this morning, Attorney Bryan Larson, who's helping us with understanding bird dogging that's happening out there, some very unethical marketing. And he has some really good insight today on this. If Bryan, you could just take it away and help us help our clients protect themselves.
Happy to do so, Jay. Thank you very much for letting me have this chance to talk to the group. People wonder what's bird dogging. Well, typically when hunters for ducks or other kinds of fowl go into the field, oftentimes they'll take dogs with them, and the dogs will have a purpose of flushing the prey out of the brush and into the air where they can pick them off, and then retrievers will go out and bring the dead birds back. And bird dogging is just basically the idea of finding clients. And over the last several years, there has developed an industry in the country, the entire nation, it's nationwide, where they have become middlemen in between the patient and the attorney representation. And I'm calling it bird dogging for lack of a better name. But these entities go by a number of different names. They go by such names as Top Injury Claim, Injury Pro, Injury Helpline, Top Law, all that sort of thing. These groups are typically not attorneys themselves, but they will direct any patient that calls into them to an attorney that's signed up under their list, and that's in the neighborhood of where that attorney, or excuse me, where that patient happens to live. Uh, I think this is a horrifically bad problem for the chiropractic industry and any healthcare provider, frankly, for who is treating people that have been involved in automobile accidents because of several reasons. First off, typically attorneys that sign up for this kind of participation, this kind of program, uh, they they may not be aware of, in which case it suggests a degree of lack of competence. But there's a law, at least in Utah, that prohibits receiving referrals in exchange for money. And depending on the financial arrangement the attorney has, it may be actually a violation of the law and a Class B misdemeanor. Actually, Class B felony. Sorry.
So this
And
falls into
that's
that pay to play.
right, pay to play stuff, and that many states have a law like that. Utah finally got on board with this last year, and I think the enforcement has been poor, but that's another area that Utah needs to improve in. There's many of those. But if an attorney is not aware of that law, that suggests lack of confidence. If they are aware of it and do it anyway, then to me that raises an ethical concern. And if they're willing to sell their soul to break the law, to be able to get a new client, that's a red flag. You don't want to work with an attorney that's that way. But also, the fact of the matter is, most attorneys that are really good don't have to advertise much. If they've been at it for any length of time, the families and friends and neighbors and acquaintances of the former clients will refer people. The attorneys will get well known in the area, and physicians will refer people to them. And there's a number of ways of doing it organically rather than having to rely exclusively on advertising. Now, most law firms do some advertising, and social networking is a very effective way of doing that. But considering the amount of time that people spend on their phones and surfing the web or surfing the net, you can see why there's a rich field here for these bird dogging entities to put out ads in the social networking arena. It's a very inexpensive way to advertise, and I've seen these things have proliferated a great deal in the last couple of years. I
Mhm.
suggest, though, that another problem with this is when you get an attorney who signs up for this typical kind of relationship, they may be not as experienced, not as competent, and maybe not as ethical, but they also may not be pro chiropractic. And to us, that's a big deal. We find, and I've learned this from decades of being in this industry, for most of these soft tissue, ligamentous, connective tissue kinds of cases, CAD injuries especially, uh, chiropractic involvement is the best way to go. That may be supplemented by other kinds of activities, physical therapy, perhaps injections or whatever, and in the rare case, maybe even surgery, depending on the individual needs of the patient. But chiropractors oftentimes do a more detailed and better job initially diagnosing and really hitting the problems and understanding the inner workings of the anatomy of the patient. And so I like to send the patient where I think they're going to get the best kind of care and have the best health result for their purpose. But many of these other attorneys don't have that same kind of perspective. And because of that, You could get a patient that is working with one of these attorneys, and that attorney will do everything they can to get the patient out of the chiropractor's care as soon as possible. In contrast to somebody that understands chiropractic, ordinarily, I mean, just for example, for our office, we will maybe like to talk to or discuss the care with a physician. We might make some suggestions like, hey, maybe get an MRI, maybe do this, maybe do that. But the physician's in charge, and we won't ever take that role away from them. And generally speaking, unless it's a really ugly situation, we won't ever refer that patient away from the chiropractic care, even if the patient takes on other kinds of care. And usually we try to consult with a chiropractor if that becomes an issue. But many other attorneys don't have that same perspective. So that's a risk. You have somebody who's not chiropractic friendly. And those kinds of situations are difficult. You also seem to have, with the type of advertising that's done through this system, they usually use the human instinct for greed and betterment, and they oftentimes promise hundreds of thousands of dollars as the result. They sometimes will talk about how there's a new program that goes around insurance. Well, first off, there is no new program. Okay, the tort system has evolved over the hundreds of years since the country has been in existence, and there's no new program with special compensation rates or something like that. The other thing too is that the value of a case, it might be in the hundreds of thousands range, but ordinarily we don't make a promise of any kind to a patient because we don't know until we know the full extent of the injuries of the patient and understand all the facts in the case. But if that patient develops an unrealistic expectation, it may be extremely difficult to be able to settle or resolve that case with that patient, who then walks away from the process thinking, well, they initially told me I was going to get hundreds of thousands of dollars, and instead I only got 25,000 or only got 50,000. And so they feel cheated. They feel, and when a patient feels that way, they will blame the attorneys, but they'll also blame the physicians, and they'll blame everybody that they perceive that's been involved with it. So unrealistic expectations. The other thing too is many of these attorneys, they will fight you every time on your lien amount. You'll have an amount that's owed, and now once in a while, sometimes when there simply isn't enough insurance available, the amount of the medical bills total more than 25,000, and maybe that's all there is. Sometimes taking a reduction is it has to happen. But these attorneys will do it on virtually every case, and they do it because they want to make themselves look better, and it's just a bad process. So, and the last point I want to make on this about why it's a risk for you is if you get an attorney that falls into this kind of category, there's a higher risk that the patient is going to have their case go to arbitration or go to trial, and the attorney's going to lose because he's just not as experienced. Well, what can be done about this? Well, first thing is you got to become aware. Healthcare providers in the personal injury area have to, whether they're chiropractors or physical therapists or MDs, they have to wake up and realize that the economic wheel that provides payment for their care and treatment, when it needs to involve an attorney, you've got to be aware of that, and you've got to not leave that up to somebody else. One of the problems is a lot of physicians feel like they sort of are either stepping out of their field, or that they are making themselves dirty somehow by merely suggesting that the patient get in and see an attorney. I get that. Look, no person in their right mind wakes up in the morning and says, I want to go see an attorney today. But in this arena, if you're going to be treated fairly at all by the insurance company, you have to have legal involvement. Otherwise, the insurance carriers don't take you seriously. And most people have heard that bit about how research has shown that typically people with attorneys get 2 to 3 times more than those without, even after the attorney's fees are paid. That's really true, and we've got numerous instances in our practice where that's happened. So you got to become aware of the role that attorneys do play in the economic process here. The world would be a better place if it wasn't necessary for that. I'd happily go do something else. But the fact of the matter is, it's a fact of reality. Once you're aware of that role, you've got to refer the patients to somebody you know and somebody you can trust, whoever that attorney might be. Do it immediately. Don't wait until after that patient has gone over $3,000 in personal injury protection. Okay. In the ordinary course of treatment of a patient with injuries, the total amount of the bills are going to exceed $3,000, which is the current threshold in Utah. And other states have similar thresholds. Some states have 5,000. Some states, I know of several different states. But the long and the short of it is, if the patient for some reason doesn't hit $3,000, either they simply quit going or the patient is miraculously better, that's fine. The attorney can close the file. No harm, no foul. But that's really the exception rather than the rule. It's I would say maybe 1 out of 100 cases is going to fall in that category. So refer them out right away. Having an attorney that is sensitive to that whole issue is a big deal. Will make a big difference for you and your practice.
That's why we're trying to get more attorneys trained across the country that are learning and certifying in these personal injury training courses that we're offering, so that they do have that sensitivity understanding of chiropractic, and they do communicate as a team player. And we sure appreciate you, Brian, you and your son, Adam, for what you do for the state of Utah in helping chiropractors, medical doctors, and PTs better serve our patients. And thank you for all you do.
Thank you. We appreciate you too, Dr. Sheldon, for all that you do and promoting the personal injury industry. We need more like you.